Good morning, ladies and gentlemen. On behalf of the President of Children's Education Society and Chairman of Oxford Educational Institutions, Management, Principal, Staff and Students of the Oxford College of Engineering, Dr. K. Valarmati, Associate Professor, Department of Biotechnology, deem it a great pleasure and privilege in welcoming you all to the 5 days International Virtual Symposium on An Insight into Biotechnological Application. This virtual symposium brings together experts and students from science and engineering and research community and explores the technological advancements in biotechnology engineering. The Oxford College of Engineering, TOCE, is one of the most prestigious institutions run by the Children's Education Society. TOCE aims at carving competent students with extraordinary skill to face challenges of the continuous changing world. TOCE provides quality training in professional education and values in engineering, management, and computer application streams. The college has 11 research centers approved by VTU to carry out PhD and MSc engineering programs. The institution is well known for its consultancy and research and development activities. Various departments have financial assistance from reputed funding agencies, namely VGST, KSCST, VTU, DRDO NRB, DAE BRNS, AICTE, ICMR, National Innovation Foundation, DBT BIRAC, such as and funding agencies to carry the need of young researchers and students in engineering and management.
The Oxford Educational Institutions Bangalore offers diploma, UG and PG courses in dental, engineering, nursing, pharmacy, physiotherapy, business management, commerce, computer application, hotel management, life sciences, electronics, chemistry, mathematics, statistics, fashion and apparel technology and management, journalism, 5 years LLB, and PUC in science, arts and commerce. Contact.
With high respect, I introduce the visionary educationist, late Vidyashri S. Narasaraju Garu, the founder of Children's Education Society. In the year 1974, Shri S. Narasaraju Garu started the Oxford Group of Educational Institutions. We remember him forever, and his blessings are there on us in all our endeavors. It is our tradition to seek the blessings of the Almighty before the start of any auspicious event. So let us start the event with invocation song.
ಶರಣು ನಿನಗೆ ಶರಣು ವಿನಾಯಕ ಶರಣು ನಿನಗೆ ಶರಣು ವಿನಾಯಕ ವಿನಾಯಕ ವಿದ್ಯಾದಾಯಕ ದೇವ ವಿನಾಯಕ ವಿದ್ಯಾದಾಯಕ ದೇವ ಶರಣು ನಿನಗೆ ಶರಣು ವಿನಾಯಕ ಶರಣು ನಿನಗೆ ಶರಣು ಪಾಶಾಂಕುಶಧರ ಮೂಷಿಕ ವಾಹನ ಸರ್ಪಾಲಂಕೃತನೇ ಗಜಾನನ ಪಾಶಾಂಕುಶಧರ ಶರಣು ನಿನಗೆ ಶರಣು ವಿನಾಯಕ ಶರಣು ನಿನಗೆ ಶರಣು.
We have an achiever and leader who is none other than Shri SNVL Narasimharaju Garu, Chairman of Oxford Educational Institutions. It is my privilege to welcome you, sir. Hearty welcome. It is my privilege to welcome Dr. Aravind A.S., Principal, the Oxford College of Engineering, and Dr. Amarnath K., Director, the Oxford Group of Institutions. I extend my heartfelt welcome to all the participants from all over India. The Department of Biotechnology Engineering is a multidisciplinary having application in multiple fields, including healthcare, agriculture, food industry, and environmental issues. It has encompassed all the fields of life and technology and is currently a multi-billion enterprise. This rapidly advancing branch was initiated in our college in the year 2003. Since then, the department is growing vertically in terms of academics, research, co-curricular and extracurricular activities, facilitating the all-round growth of students. The department is permanently affiliated to VTU and has been accredited by the National Board of Accreditation and NAC. The department has bagged ranks in both UG and PG programs. The department has excellent infrastructure involving well-maintained classrooms and highly equipped laboratories which are designed for today's technological challenges. The department is doing outstanding research work in PTU Approved Research and Development Center. The department has established unique research facilities, namely Center for Natural Product Research with financial assistance from VTU, AICTE New Delhi and DAE BRNS DRDO New Delhi. And then Center for Computational Medicinal Chemistry in Drug Discovery with financial assistance from Vision Group of Science and Technology, Government of Karnataka. And Center for Bioremediation with financial assistance from Naval Research Board DRDO, New Delhi and DBT BIRAC New Delhi. In these R&D centers, several funded research projects have already been conducted and continuing research grants have been received from various national and state government funding agencies like DBT, BIRAC, DRDO, NRB, DAE, BRNS, AICTE, BGST, KFS, VTU, KSCST, and National Innovation Foundation, etc. These projects are instrumental in strengthening our core research activities, which are beneficial to both students and staff. They have also generated sufficient amount of funds to equip our department with necessary instrumentation and other requirements. At present, the department is working on the development of bioremediation kit for the remediation of oil spill and degradation of toxic hydrocarbons under the financial assistance of DBT BIRAC under PACE scheme under the guidance of Dr. B.K. Manjunath, Dean Research and Professor and Head, the Department of Biotechnology. Department is also working on developing polyherbal formulations to reduce the toxic effect of radiation during the radiotherapy under the financial assistance of DAE BRNS, New Delhi, under the guidance of Dr. B.K. Manjunath, Dean Research and Professor and Head, Department of Biotechnology. The department is actively engaged in extending consultancy services to validate ethnomedicinal claims of traditional medicinal plants under the financial assistance of National Innovation Foundation under the guidance of Dr. B.K. Manjunath, Dean Research and Professor and Head, Department of Biotechnology. Highly qualified and seasoned faculties who are capable of nurturing the overall growth of students are also actively involved in conducting various programs and activities in the department. The department is proud to state that a domestic patent is filed and a bioremediation product, PetroSAP, is developed to address the bioremediation of hydrocarbons and oil spill with financial assistance under BIRAC. Now, I request Dr. B.K. Manjunath, Professor and Head, Department of Biotechnology, to give an overview about the objectives of the International Virtual Symposium on an insight into biotechnological application. I welcome you, sir.
Okay. A warm welcome and very good morning to one and all present here. It gives me immense pleasure in welcoming all of you to this 5 days virtual symposium. In the dynamic and competitive environment, it is very challenging for the Engineering Education Institute to prepare future leaders and engineers. To follow the rhythm of extremely fast and globally developed India, the 21st century engineers should have the capability to deal with the global issues and understand sophisticated multidisciplinary and multicultural problems. They need to develop their minds to think in multidisciplinary approach, and they should be trained in a way to link topics of different subjects and disciplines in order to propose the most suitable solutions wherever society demands, especially in the pandemic situation like this. Hence, the educational institutes are not just constrained to knowledge transfer from teachers to the students, but are also involved in knowledge assimilation, knowledge generation, and knowledge spreading. The main objective of this 5 days virtual technical symposium is to bring experts, researchers, and innovators from academia, R&D institutes, and industry in the different fields of engineering and science subjects together, and to provide them a forum for knowing what is happening in the research arena, identify and conceptualize new ideas, and sharing their valuable findings and thoughts. The symposium also aims to create research interest in the minds of young graduates to pursue research as their career. This symposium will facilitate and promote interdisciplinary research among students and helps in reducing the gap between the different engineering domains. Hope this effort will help us understanding the various domains of biotechnology, and I extremely happy to convey my heartily felt thanks to all the participants for joining hands with us. Come, let's make Atmanirbhar Bharat together. Thank you.
At the outset, I welcome today's guest, Mr. Joshua Abraham, Assistant Director, Patent Analytics Hub, IP Australia. He has 12 years of experience in IP sector. He started his career in India working with GVK Bio in the protein modeling and drug designing team, and then he moved to the IP team. He worked with AkzoNobel in Netherlands and Covestro in Germany as IP manager. Presently, he is working with the Australian Patent Office, IP Australia, as Assistant Director with Patent Analytics team. On behalf of the management, staff, students of the Department of Biotechnology, I would like to extend a very warm welcome to Mr. Joshua Abraham for today's webinar. Welcome, Mr. Joshua.
Thank you, Dr. Valamudi. And it is a great pleasure to be with you today. And it's an honor also to get to know about how the college started and the pioneers in the field who made this happen. It's also a privilege to listen to Dr. B.K. Manjunath and also listen to all his achievements. I'm really honored to be here and to give a talk over here about IPR and its relevance to India. I'll start sharing my screen. Please let me know if you can see it. Yep. Can you see it?
Yeah.
Thank you. So before I get into the details of what I'm going to present, I'm really happy to look at the title, An Insight to Biotechnological Applications. And the topic of IPR is really relevant to biotechnology, as we all know. And especially in an Indian context, there is a lot of understanding that is needed and a lot of application that is needed when it comes to IPR. And I hope I achieve that by stimulating your minds to think more about IP and what it includes and how it can help us and also our country in the end. So I'm Joshua. I'm an IP professional for the last 12 years. I've worked with the IP services industry in India. I've worked in in-house teams with 2 different companies. And now I'm working with the IP office over here in Australia. So that's a short summary, which also Dr. Valamudi explained. How did IPR begin? If I have to talk to you about it, before we get into it, what was the need for IPR to be created? Thomas Jefferson, the 3rd President of the United States, he says, "He who receives an idea from me receives instruction himself without lessening mine, as he who lights his taper at mine receives light without darkening me." So which means,
Joshua,
so if
can you hold
sorry,
on for some time? 1 minute, there's some network issues.
Sure.
Just 1 minute. Now we can see.
Okay.
Can
you hear me properly also? Okay, I can do it. No worries. So I'll start from my introduction. I'm Joshua, and I'm an IP professional with about 12 years of experience working in various sectors in the IP services sector in India, working in in-house teams in Netherlands and Germany, and now I'm working with the IP office over here in Australia. As I was saying before, it is very important to understand how IP is important, especially for a biotech department or for a biotech student. Not only that, but also for the country as a whole. So I'd like to introduce you to how this all began. So how did it all begin? Before we go there, I would like to turn your attention to a quote from Thomas Jefferson, the 3rd President of the United States. He says, "He who receives an idea from me receives instruction himself without lessening mine, as he who lights his taper at mine receives light without darkening me." So the meaning of this quote is, I mean, if I use somebody else's candle to lighten my candle, it's not going to darken the other person's candle or the other person's light. So if I pass on my ideas and my information that I have to somebody else, they introduced the British patent law in the year 1852 in Great Britain, and they introduced it into India in the year 1856. So from an Indian perspective, we are not new to the concept of IPR or the intellectual property rights. This continued until 1970 when major changes were made. It went through a political process, and so the Patents Act of 1970 was born. So usually if you refer to the Indian patent law, it's called as the Patent Acts of 1970. And then there were modifications made, which I will explain in detail later. And the most recent modification was made in 2005 because we became a party to the TRIPS agreement. So that, again, I'll talk to you in the later slides. So this is the history. We are not new. We've been with the system for over 100 years, and so moving on. When we talk about TRIPS or trade-related aspects of intellectual property rights, we would all have studied it in some detail, or we may study it in our syllabuses. I mean, when I'm talking to the students. What it meant was almost all the countries who are part of the World Trade Organization, they agreed to a minimum standard of IP protection, so intellectual property protection. They said that we would all come together, we will all agree to have certain standards, a common standard, to say that it is okay to work with each other. I mean, the reason being different countries had different laws and different rules, and it was not workable with each other. So it was bringing in a lot of conflict. So all the countries agreed to have a minimum standard, and thus this trade-related aspects of intellectual property rights was born. And every country that signed an agreement to that, they had to modify their IP laws or make changes to adapt themselves or to accept these minimum standards that were proposed. So India as well agreed to do that, and this came into force in 1995. And later on, a lot of changes were made. And one of the major changes that happened in the Indian patent law was we allowed patents for pharmaceutical products. Now, when we are talking about patents for pharmaceutical products, I'm going to explain this later again. Until 2005, until the last major change that was made, there were no patents for pharmaceutical products. So which meant companies could not file a patent on a particular pharmaceutical product. And there were few groups of Indian manufacturers who used to copy pharmaceutical patents from countries abroad, and they would make drugs for the Indian market, and they would sell it within the Indian market. And now, this situation was interesting in the sense that it helped Indian companies to copy patents from foreign companies and manufacture it in India without any problem. Nobody could challenge them. Now, the problems were for the foreign companies, if they had to come into Indian market, they had product patents, and they could not come into the market with protection because they said, oh, you don't have any protection, anybody can copy our drug, and we do not want to enter into the Indian market. So this kind of created a monopoly for Indian manufacturers, and they were enjoying the benefits of it. But what did we lose on is we could not bring in companies to invest in India, which meant that we did not have the latest technology available in India when it comes to manufacturing drugs. And this also meant that we could not export our products to the global market, which was again a limitation. So when these amendments were made, and when we said we would live by the common minimum agreements that were made in the TRIPS agreement, we had to make changes, and it was a workable situation for everybody. So this was a big benefit to India. Now, when we are talking about this TRIPS agreement and the World Trade Agreement, I'm sure you'll be having these questions about what IPR is. I mean, I should have talked to you about what IPR is. I should have explained to you what it means, and I did not do that. Now, that was done intentionally because I wanted to understand the situation that we were in before we get into the details of it. So what is IPR? IPR is intellectual property rights, and it is a legal right that is given to protect the creation of the intellect or the creation of the mind. So anything that is a product of the brain, you need to have a protection. And that is why it is a legal right, and it is granted to give you some level of protection over what you've created. So when we talk about inventions, you have patents and utility models that give you that protection. When you talk about the way a particular product appears, you have designs protection. When you talk about logos, brands, words, and phrases that are commonly used, then it is protected by trademarks. When we talk about literature, art, and scientific literature that is published, that is protected by copyrights. When you talk about creating different plant varieties, then it's protected by plant breeder rights. When you talk about products that have a specific origin, then we go for geographical indications. So I'll give you an example for all of these different rights to give you a better understanding of what I'm talking about. When we talk about inventions, so we always know that there is a new invention or something that's new in the market, or something that adds value, or something that is never known to the history of mankind. These are called inventions. And that is usually in the technological area. It could be in the electronics field, electrical field, mechanics, or even biotechnology, pharma, chemistry. So these inventions, or anything that is to do with a scientific discovery, is protected by patents and utility models. Now, what do you mean by patents and utility models? Aren't they the same? They are the same. The only thing is, when we talk about patent, it goes through a rigorous check, and there's a strict criteria. For a utility model, there is not so much, and it's an easier way to get protection, although it doesn't give you full protection. When we talk about product appearance, you can think about the way something is designed, the way a cup is designed, or the way a motorbike seat is designed, or the way a chair is designed. And all of these designs, they are all protected by these designs-related intellectual property rights. And again, when we talk about trademarks, you see a lot of trademarks that are out there, and how easy it is to just copy one trademark to another, or how easy it is to use a different word to make it sound like the original trademark. Like if you would have seen, there are all these fake goods that come into the market. So if you talk about Nike, they probably would misspell the word Nike and bring it into the market. That is because they are trying to avoid the trademark right held by the Nike brand. They are trying to bring their product into the market. They don't always escape because they can be taken to court. So that is, again, something that gives you protection. And when we talk about copyrights, literature, music, art, and scientific works, even books, pictures, they all have copyrights in them. We in India, we sometimes, without realizing the impact of it, we make photocopies of our books or notes or things like that, which is forbidden by the copyright law. We cannot do that. Sometimes we copy whole books. We make photocopies of it because it's cheaper than buying an original book. It is not actually right to do that. Plant breeders' rights, when we create a new plant or a different variety of a plant or a different plant with a different flower characteristic or a fruit characteristic, you have the right to file plant breeder rights. So it gives you right over that particular plant so that nobody can copy it or create or take it away from you. And then again, the last thing, geographical indications. You would have heard of basmati rice in India, the Tirupati laddu in India, the Kanchipuram silk sarees. So anything that a product that has a specific affiliation to a particular market or a country or the name of a place, and if it has a particular characteristic, then you get geographical indication rights over that. So these are the different kinds of intellectual property rights that are there. I'll give you an example, and you can understand it better over there. Now, let's take this example of this Victory motorcycles and their Hammer brand. So over here, if you talk about how this whole motorbike is protected, if you look at the logo, that is Hammer or Victory, they are protected by trademarks. They are definitely protected by trademarks and nobody can copy them. And again, when you look at the seat, the design of the seat, they are protected by designs. The engine, if it adds some, if it increases fuel efficiency, or if it increases the speed, or if it does something different, there would always be a pattern that protects that. And then the advertisement. So when you talk about advertisement, when you look at the way they advertise, the picture and everything, it's covered by copyrights. Now, if you ask me, I did not break any copyright law when I took this picture, because there are certain websites which give you royalty-free images. So this is one of them, and I'm very careful about that when I use that in my site. And I would encourage you as well, when you work on your projects or when you prepare your project report, make sure that the images that you use are copyright-free, or you attribute the image to that particular source in whatever you do. If you do not do that, you are breaching copyright law. I mean, nobody is going to come after you and file a case against you, but this is something that you need to understand and bring it into your DNA to make sure that when you finish your education and move into a corporate environment, these are things that are very important that you need to be aware of. So, when you talk about advertisement, there are different things that they use, different themes that they use, different words that they use to target the audience. All of that is covered under copyrights. So this is an example of how IPR works. Now, I'm not going to go into all of these IPR rights because that's a very extensive topic. So what I'm going to do is I'm going to talk more about patents over here. Now, this image that I have over here is on purpose. I mean, what are patents? It's like we are there in a forest and we do not know what to look at, where to look for, and we don't understand anything because we are so covered by everything and we are in a confusion. And I'm trying to make sure that you get an understanding of what patents are. So now, when we talk about patents, as we saw earlier, they are used to give you legal protection over your invention for a particular period of time. So a patent gives you protection for, most countries say that they give you protection for 20 years. So for 20 years, when you file a patent, and if your patent is granted, you can use it and nobody else can use it. Now, I'm going to deal with that in detail. But before that, what are the criteria for getting a patent? There's 4 different criteria. Different countries have different criteria, but they can be summed up in these 4. The first thing is a patent should be patentable, novel, it should be non-obvious, and it should have an industrial use or applicability. So when I talk about patentable, what do you mean by that? When I talk about a patent being patentable, or your idea or invention being patentable, you cannot patent just plain ideas. You cannot patent abstract ideas. So let me draw a clear distinction over there. If you think of something, and if you think that this is a very good idea, make sure that it is workable, because if you cannot do that, it cannot be patented also, because you need to provide specific examples when you file a patent application. And again, mathematical concepts, algorithms cannot be patented. And also, if you have religious views and if you have religious ideas, they cannot be patented. And again, if you have extreme ideas, or even if it's some invention that is extreme, that does not help for the human society's development, example, anything that is of sexual nature, anything that is destructive, cannot be patentable. These are all conditions that are there in the patent laws. So basically, if you have an invention, you have to make sure that it is useful for everybody, and that it is not destructive. So anything that is related to nuclear technology or a nuclear bomb or something, You cannot file a patent on it. If you file a patent on it, the patent offices will notify the Atomic Energy Department of that particular country, and your invention or your idea will be stopped from being published. And you'll have to talk to different people after that. So that is one of the things. The second thing is it should be novel. When I say it should be novel, it should be new. It should not have been present before. So, for example, if you make a drug, if you're talking about a drug, this should be a completely different chemical structure, and it should be a new one, and it should not be. It should not have been known already. So, how do you think that you can prove that? Even if you say that your idea is novel, the patent offices, they have people who will check your inventions, look for available literature that is there in the public domain, and they will determine if your invention is novel. And the second step is it should be non-obvious. Now, not all inventions are breakthrough inventions. You can also have innovations, or you can have things that add on to what is already existing. So, for example, if you have a particular drug and it's in a particular form, let's say if it's in a liquid form, and you have you've created a solid form, and if creating that solid form is not known, and if when the original person was making the liquid form of that drug found it challenging to create a solid form of that drug, then you meet the non-obvious criteria. But if the person who made the liquid form has also kind of disclosed, saying that you can make another drug that is in a solid form, it becomes obvious. So these are the criteria that they check on. And the third criteria is industrial use or applicability. Your invention that you claim should be applicable for an industrial use or purpose. So which means they want to know if you've solved a particular problem. Does it recognize a particular problem that the industry is dealing with? And does it provide a solution to the problem for that particular industry? So if we take a drug, for instance, we have this corona situation, and we say that we have invented a drug which was in a liquid form, and now you've created it into a solid form, and that increases efficiency and bioavailability and other things that are there. Now, when we have to assess under these conditions, is it patentable? Yes, because it is an invention. It's a technological one. It's useful to the general public. Is it novel? Yes, because it is a solid form. It has increased efficiency and bioavailability. Is it non-obvious? Yes. Is there an industrial use to it? Yes, of course, because if you look at the current situation, people are dealing with the coronavirus, and there's no way to cure this, and your drug has greater efficiency and solves the problem. So there is an industrial use to your patenting criteria. So if you meet all of that, you've got a great invention, and you can go ahead to file a patent. So when we talk about the patenting process, what do we do? Now I have an invention. I know that it has met all the criteria. I've tried to assess it. Now I go to the patent office to file an application. So when I file an application, before I file the application, I check for myself what my invention is all about. And then I have to use a patent agent to draft a patent application, to write a patent application in a particular way. I'll show you what a patent looks like. That will give you more information about that. So writing a patent application is not like writing a summary. It's not something that everybody can do. You need to have a specific amount of legal training to be able to write a patent application. So you use people who are trained for that. And then you file a patent application, and the patent office publishes your patent application. Now, at this stage, it does not mean that you have a patent granted and you have your right over it. Patent office, if it publishes, it is a normal process, and it does not give you any right over your invention, because after that, what the patent office will do is it will examine your patent application, and then it would make a decision to grant or reject. There are many steps in this process. I would not want to confuse you through all of that. So this is a very simplified explanation for that. If you would like to have more information on that, you could always approach me, or it's also available on the Patent Office website. So there are also fees involved for each step. So you need to pay fees and everything over there. So the reason why I thought I'll make this clear to you is many people out there in the industry, not in the industry, but in the research community, have this confusion that as soon as their patent is published, it somehow gives them the right over their invention or over what they are protecting. It does not. What it does is it makes your invention and your idea public, and if it's not granted, anybody is free to use your invention. So you need to make sure that you have a new invention, and you have to make the payments for each step for the grant as well. And once the Patent Office grants your application, once the Patent Office grants a patent right over your invention, then you have guaranteed protection over your invention. Now, when we talk about guaranteed protection, it depends on where you file your application. So if I file it only in India, I have my rights only in India. If I file in the US, I have my rights only in the US. It does not give me the right over every other country. And if I want my right in every country, I have to go to every country. Now, to make this decision to go to each and every country, it depends on the market need. It depends on what your invention is and what the aspirations of that particular country is, and what the appetite is for that particular technology. So say for example, for instance, if I bring a drug, or if I have a patent granted, or if I know that I have this invention, it's new, and it has a big market, it is good to file patents in all the big countries where the market will be huge. So that is one of the reasons why there are big companies who file patents in every country. It's a very expensive thing to do, but if you think there's returns on your investment, please go ahead and do it. But again, on the other hand, for some cases, like for small inventions, if you know that the market is not big, you could always try to file it in your local country and protect your invention. So it depends how you want to make the decision, but this is how it's done usually. Now, when we look at these inventions we are talking about and the types of patents, I talked to you about utility models. I'm not going to talk about utility models anymore because it does not give you the full rights. But when we talk about patents, there are two kinds of patents. One is the product patent, and the other one is a process patent. So this came about in the year 2005 in India when we started having product patents. So, which means you can file a patent on a particular product, which is a drug, and you can file a patent on a process of making a drug. Now, these are two different things. These are not one and the same. If you have identified a drug, if you have a drug A, let's say, for example, you file a patent just for that drug A, and it grants you permission or rights over that particular drug A. Now, and then if you have a particular way of making that drug A, and if you think that is very novel, very new, it is important that you also file a patent for a process. So that is called a process patent. And there could be there are companies that have different processes for one drug. You could have 10 different processes for making one drug. And if all those processes are useful, now you would want to file a process patent. In India, I'm talking about the Indian context, I'm not talking about the global one. In India, until 2005, we had only process patents. So which means if you had a drug A, you will not be able to file a patent for patent protection for the drug compound. You will only be able to file a process patent. So you can say that this is the way you make that drug, and you can file a patent application. Now that it looks like that you have a protection. And it would be okay if you've had only one way of making that drug. But if somebody else comes up with a different way of making that drug, he can file a process patent on that drug, and he can make it through his way, and he can start marketing your drug, and you cannot do anything about it. Now, this was the problem global companies faced, because the idea was they also wanted to have protection on their product and the process. India was not allowing that until 2005, which that is why you see a lot of pharma companies in India. And this was one of the reasons why a lot of pharma companies had a lot of businesses in India, where they would copy the processes, the products from foreign countries, and they would adapt the process, or they would try to invent a different process, and then they can manufacture their drug and they would market their drug. So as I pointed out in the beginning, this caused a lot of problems in terms of the country not having access to the latest drugs. So countries would not want to disclose how they did it. They would not want to teach us how they did it, and they would not want to bring in their products into our market. So we had to bring in protection in our patent laws and say, okay, we will protect products as well. And so that was the result wherein we started getting in a lot of foreign companies coming into India. And I'm not sure if you're aware, a lot of drugs were banned around that time and before that. And the reason was for the introduction of these product patents. So when the product patents were about to be introduced, many companies said that they would want these drugs to be stopped, because that would allow them to enter into the market. So some drugs were stopped, some drugs were allowed to continue, and it was decided on a case-by-case basis. So these are the two different kinds of patents from a biotechnological perspective, and also from every perspective. Now, taking you to how do patents look like. So this is how the patent looks like. I mean, this is an Indian patent. It gives you an application number, and you have the name of the applicant or the company that's invented it, and then you have these inventors, and you have a brief abstract about what this invention is all about. The next page, I'm going to show you what it looks like. So they have to talk about the technical field of the invention. They have to talk about the background of the invention, and the patent has to talk about detailed description of the invention. As I already mentioned in Thomas Jefferson's quote, the idea is to pass on knowledge, to share knowledge, and not to withhold knowledge. So when you talk about a patent, the patent talks about a technical field, what it does in short. And when we talk about the background of the invention, usually over here, they talk about common solutions that are there in the market, and how these solutions are not sufficient enough, and how their invention tries to address that problem. So in legal terms, they call it the problem solution approach. So which means that there is a problem, and nobody has found a solution to the problem, and your invention kind of brings the solution to the problem. And that is how you're bringing in that approach. So that is why that's called a problem solution approach. So now you've described the background of your invention and what you were trying to solve. And here you have to bring in a detailed description of what your invention is all about. If you do not give a detailed description of your invention, your patent can be invalid, or it can be taken to court, and the court will say that it does not allow anybody to practice properly, so you have no rights over it. This is one of the criteria that is there in the patent law. Now, all of this is fine, and you need to be very careful. This is why I said that you need somebody who has a legal knowledge or a legal background, who will be able to write a patent application. So these are some of the things, but the key thing in a patent is the claims. Now, this is the legal part of your whole patent. So you're trying to write your invention in legal language, and you're trying to protect it. So this is called the claims, and wherever you go, and if you have a court case or something, the court will be looking only at the claims and not at the description. So what you claim is what you can protect, and what you've described is not what you can protect. So that is the distinction over here. So when we talk about the claims, you need to make sure that you've covered everything. When you read the way claims are written, it's written in such a way that it is not too broad and not too narrow. And you have to kind of play with the words and make sure that everything is proper. So when I look at this claim one, that is the broadest claim, that's how they call it. They say a nanoparticle delivery system comprising a self-assembling reconstituted high-density lipoprotein complex comprising a specific polymer, crosslinker, receptor, and a drug. In nowhere over here have they defined what that specific polymer is, what that crosslinker is, what that receptor binding component is, and what that drug is. You see how vague it is over here? And the reason why they leave it like this is because in the description, they would have listed a list of polymers. They would have listed a list of crosslinkers. They would have listed a list of receptor binding components and a list of drugs that might potentially work. So now, I said that in the beginning, if you have a drug, you go ahead and patent a drug. But if you are using a drug in combination with other components, you might want to think about other components as well that might be useful. And so you make sure that you just use the broad terminology. And in the description, you can define what that specific polymer is. So if there are 3 different polymers that might work in your invention, it is very worthwhile to bring that in your description and say the specific pH-specific polymer could be polymer A, polymer B, and polymer C. And if it's a crosslinker, there are different crosslinkers that are there, and it's very important that you make sure that you list them in your description. This is a way to kind of protect what your invention is all about, and also protect possible inventions that could come out of your invention. So this is a way of disclosing and also preventing others from filing a patent. So you can think about it in these terms. If you have a house, you build a house, and then you put a boundary wall. So the claims are the boundary wall. You build a house, and you have some space around your house, and then you put a boundary wall around. So that kind of the space is where it gives you a little bit of freedom to move around, little bit of freedom to make sure that you prevent other people from coming in, and little bit of freedom for you to explore your invention as well. So if you've built a house, later on you might decide that you want to do it in a different way, or you might want to extend the house. That space between your compound and your house allows you to do that. So a claim construction, or the way you write claims, also is done in a similar manner, where you have to make sure that you leave a little bit of room in 20 years' time when things do develop really fast, that you have the ability to protect your invention a little bit broader. You can't go too broad. You cannot bring every polymer or every crosslinker into your invention and say this is how it is. You need to give specific examples as well. So you have your boundaries and limitations, but you want to stretch those limitations a little bit. So when you have a patent and when you write a claim, use a proper person who has a good understanding of the legal background and also has a good understanding of a scientific background to be able to write these claims. And it's very important that you do this. There have been many cases where the claims have not been written properly or written very poorly. English language is very important. Now, you may argue and say, English is not that important. English is only knowledge. It's only a language. It's not knowledge. All of that is true. But when you're entering into the international market, you need to make sure that what you have written is written properly, because let me point it out. Now, when you talk about claim 1, it says a nanoparticle delivery system. So which means that you are defining the nanoparticle delivery system. When you go to the court reads it this way. So you need to define it. And then from claim 2 onwards, you see it is called the nanoparticle, which means you're referring to this one. Now, instead of the in claim 2, if you start using a nanoparticle, like how you did for claim 1, you're causing confusion in the way you're writing your claims. And many people have done that, and they've lost protection over their inventions. Now, maybe you might think you don't have to be aware of all that. It is very important that you are aware of these things, even when you write your thesis, even when you write scientific journals, and when later on, if you come to this state where you would want to file a patent application, make sure that you pay attention to all of these. So that's very important as well. Moving on to the next one. Now, patents for students and researchers. Now, I spoke to you about what a patent is and what a patent looks like, and you've seen what all will be there in a patent. What does it mean for students? What do I get from patents? Now, you need to understand patent information is free and completely available. Now, this is different from your journals and other things where you need to pay or you need to have specific access and you need to be a subscriber to certain journals to have access. For patents, it is not the case. Patent information is free and a patent information is available. And one of the conditions of patents is the information that is there on a patent should enable a person in that particular area to be able to replicate that invention. So, which means if I file a patent for a drug, I should write it in such a way that somebody else can also make it. Now, that is why patents is giving me 20 years of protection, so nobody can make it. But after 20 years, they should be able to make that particular invention according to what I've described. Now, if I have not described or if I have not disclosed fully, anybody can go to court and say that this does not disclose everything completely, so this patent cannot be granted. And the court will say this patent will be invalidated. So that patent will be invalid. So it is very useful information. Patent information is very useful. And again, one other thing about patents is that with patents, you always get the current technology as well. So the latest technology, the latest developments are always available in full, and it is easily workable. So what does this mean? Many students these days, when you go through all these scientific journals to get ideas about what to do in a particular area for your projects or for whatever you do, for your research, I would encourage you strongly to try to look at patents as well, because patent information is latest. And when you start doing that, this way you can avoid reinventing the wheel, which means you don't have to do what somebody else has already done. You can learn from what somebody else has done, and you can start thinking about it to develop your own ideas or to build on these inventions or to build new products and new processes. There are many different sources. There is a patent database from the European Patent Office. And if you go there, you can put in your keywords and look for specific patent information there relevant to your particular area that you're working on and things like that and so on and so forth. So for students and researchers, patent information is very useful and very reliable. So please use that. Now, we have different patent offices in India. We have 4 different patent offices. We have a patent office in Mumbai, which is the headquarters. We have patent offices in Delhi, Kolkata, and Chennai. So if you have a patent application, if you've written a patent application, you go to one of these offices and you can file a patent application and start the process for granting a patent. Moving on, now I'm going to talk about the relevance of IPR in India. Now I have a picture over here where the guy is looking outside. Now we've talked about what IPR is. We've talked about how IPR came into India, and we've talked about the major changes that came to India and how we are benefiting. Now we need to look at the relevance. So let's focus on other things. Let's take a step back. Let's look at what's happening around the world, like how this man is looking outside the window. He's busy doing something on his phone, but he takes a moment. He looks outside to see what it's like outside. What's the weather outside like? What is the condition outside like? And this kind of helps us to compare ourselves with the global market. And I want this. The reason why I brought in these slides is because I want to instigate certain things in your mind, put certain ideas in your mind for you to think about IP and how you could bring that into your curriculum as well. So when we talk about how it is globally, when we look at the global figure, these are not figures that I worked on, but these are figures from the World Intellectual Property Organization. This is an organization that under which all of these countries they come under, and their IP offices, they work together with World Intellectual Property Organization in bringing policies that help everybody. And this office, they also release studies every year. So from their 2019 study, they studied how patent applications have been going on, and they took the top 5 IP offices. So China, US, Japan, Republic of Korea, and the European Patent Office. And if you see, the graph for China is peaking. It's huge. China has been making rapid strides, and they've been growing tremendously when it comes to IP. It is also the reason is China has a lot of universities, and there's a lot of focus on IP. And China didn't start very early as well. It started somewhere around the early 90s, late 80s, early 90s, and it was slow. But after 2005, they've been growing tremendously. And if you look at that, that's the picture of where China is. Now we need to ask ourselves the question: where do we fit in? How does India compare? I'm going to show that in the next slide. When we talk about India, India doesn't come in the top 5. India comes in the top 10 when we compare it to the market. But what is happening in India, if you look at it closely, there are 3 things that this graph considers. There is a granted, there's a portion called rejected, and there is withdrawn and abandoned. So if you look at that, the bottom portion for India is the number of patents that are granted. So there are very less patents that are granted or that come out as grants. And when we talk about rejections, not many patent applications are rejected. So there are many genuine applications as well. But what is disconcerting is this huge bar of withdrawn or abandoned, which means, now I told you that in the beginning when we talked about filing a patent, you have your idea, you file a patent application, your patent office publishes your patent application. But after that, you need to keep paying fees. Now, if you don't keep paying fees, even for granting, if you don't pay the fees, the patent office will consider that your application is withdrawn or it is abandoned. There is a reason why this happens over here. A lot of people are not aware that the Indian government provides support for filing a patent application and taking it through the grant. So there are many organizations that support you. And there are many organizations that provide you with funding. But then there are not many people who are aware of that and who just let their applications and they just get abandoned or they are withdrawn. Now, there are also there's also another set of people who think if you file a patent application, you somehow get the protection and they don't need to do anything about it. So this is, again, the lack of awareness in our country, where they think that once they have filed their application, it's done and it's dusted and they have some sort of protection over there. But you need to make sure that if you're not paying the fees that have to be paid, your application can be abandoned by the Indian Patent Office. It will be there in the public domain for everybody to see. But after a certain period, you cannot do anything to revive it and ask the Patent Office to grant it. They have specific deadlines, and if you don't meet those deadlines, they have certain grace periods. And after that grace period, you cannot do anything about it. Your patent application that is published is as good as a paper publication, and it will be there, and anybody can use it. You will not be able to protect it, or you will not be able to exercise your right over it. So this is one of the biggest drawbacks in the Indian system, where there is lack of awareness. So as students or researchers, I do receive a lot of requests from different students from across our country to help me with patent applications. Now, this is one of the comments that I get. Now, what do I have to do to get my patent right? They think it is easy. It's not. So this will give you the awareness. Just be aware. I don't want you to remember everything that is being said, but be aware. You need to make sure that there are fees that have to be paid. You need to make sure that your application is granted. And again, there are maintenance fees as well. This is a very sad picture for India, and this is something that we need to understand from an Indian perspective. And as students, my hope is that you get this message and that you spread the awareness around. Now, the next thing is countries that specialize in different technologies. If you look at that, India does not come anywhere over here. Does that mean India doesn't do anything? I would not say so, because I know there's a lot of activity, research activity going on in India, but the problem is with the conversion. Now, if you take the case of China, anything that they do, any little improvement that they do, they can go and file a patent application. They definitely do it. And the Chinese patent office is very helpful, and they are very competitive, and they make sure that their inventions are registered. They make sure that there is enough support for them. And that is the reason why you see there's a huge spike in the numbers. Now, it doesn't matter if it's a good patent application or if it's a bad patent application. China somehow gets it in, and then they make changes later on. So when you talk about the technology, you see that China is the world leader when it comes to computer technology. What they mean by computer technology is anything that has to do with artificial intelligence, machine learning, and they are ahead of Japan as well. US does share the space with China, but there are more coming out of China than the US. Now, there is a lot in medical technology, optics, transport, mechanical elements, measurements, and so on. So these are the top countries that have a lot of activity in patent protection: China, Germany, Japan, Korea, and the US. It's quite obvious. Germany is known for its cars, automotives, electronics. Japan is known for its electronics. Korea is known for its electronics, and US is known for all technology areas. So my idea in the previous slide was to give you an idea of how countries are focusing on different technology areas and where we as a country need to think of as well. If we have to improve in our technology space, and if we have to become competitive, we need to have a picture of what's happening in the global area, and we need to compare ourselves and not to feel small or not to belittle ourselves, but these information should be taken with the right attitude to move ahead in these areas. Now, again, when we talk about the relevance of IPR in an Indian context, we all know about this famous case. Talking to a biotech audience, I am sure you know about this Nexavar case, which is Bayer versus Natco Pharma. So Nexavar is a chemical compound that is very useful and efficient for liver, kidney, and thyroid cancer. And there's this company called Bayer, and they had a product patent on it. And they also filed a product patent application in India. They got their product patent granted. But the cost of that drug in the Indian market for a month was about $5,500 US. So if $1 is about 60 rupees, you can work out the math for that. And it was in lakhs, which was not affordable for most of the population. Now, the Indian government took notice of that, and there is a provision where the Indian government can step in, and they said that they would take the patent on their own. They would take the ownership. The government would take the ownership, and it would give somebody else that right to make the same drug for a lower price. Now, there was this company called Natco Pharma, an Indian company, which offered to make it available for $170 US, so tens of thousands compared to lakhs, for the Indian public for a month for the treatment using that drug. Now, why do I want to bring this to your attention is because this case had global attention, and as people who are in the life sciences area, we need to be aware of this case. The Indian government, they said that they would take this patent, and that is called compulsory licensing, and they gave it to Natco Pharma. Now, Bayer, they filed a court case. They fought against the Indian government. They wanted to market this drug because they said we invented it, we put in all the R&D, we brought in all the infrastructure, and we invented the drug, so we have the right to fix the price, which is $5,500. And that was too expensive for the Indian market. So their argument was, if it is not affordable, that's not my problem because I need to get back my money. The Indian government said, now we are going to take it from you and we will give you what is right, but we will have the license. So the Indian government took ownership of the patent and they said that they give 7% of the profit on this drug to Bayer. So Natco Pharma agreed to make this drug for $170 and they have been manufacturing this drug in India. There are a lot of things that you as students should be aware of this. The way the international media sold this was, oh, India is so against IPR. India, if you file a patent in India for something that's useful, the government will step in and they'll steal your invention and they'll give it to somebody else, they'll make money out of it. That is not the case. You need to be aware this 7% out of the profits that was granted to Bayer was good enough for them. It probably did not give them this huge amount of profit, but it compensated for the research effort. It compensated for the amount of clinical trials, studies that they spent on, and it compensated also for the profit. So it was not unfair. It was fair. It did not allow somebody to just make money out of the Indian population. So the government stepped in. Government was conscious of what was happening. And it happens. It has happened in the US before, but that was years ago. But recently, India does that. So how does this matter to India? How is it relevant for an Indian context? So when we look at these, when we look at foreign companies coming into India, there are all of these arguments against IPR. They say, it stops companies and it stops inventions. It does not incentivize companies from marketing their products, but it is not so. And you need to know of these cases as well. So this is the relevance of IPR with an example. So Bayer versus Natco Pharma, please be aware of that. As a biotechnology student, you should be knowing this. So what is the key takeaway from here? What should you as a student do? Now you've learned about a case, you've learned about the statistics. What should you do? What do I want you to take away from here? Create awareness, create awareness, create awareness. Don't forget that. As a student, as a biotech professional, create awareness on the ways to protect and the ways to use intellectual property. Ethically, not unethically. Now, the next step is, how do you use IP data? I showed you different graphs. All of this data is available. Now, use this IP data to benchmark yourself, benchmark your research capabilities, benchmark your study capabilities. Now, what does that mean? Now, if you're having an idea about your project, you would have all these mini projects, major projects. If you have all of these ideas, use the IP data, study the IP data, see what you can develop further. If you have an idea, go look into these patent databases, see if there have been similar cases or similar inventions that have been done. And in most cases, you will always find that there is somebody who has done something. And if you found somebody who has done something, see if you can replicate that as your project or see if you can do something better. That is how you need to benchmark. So that helps you to practice that particular invention, and that also helps you to develop your creative abilities. Now, once you've done that, make sure that you start developing your capabilities to reach global standards. Now, what is that? What do I mean by that? Use the IP data, because a lot of students in our country, when they don't use these patent information that is available, you start reinventing the same wheel, you start doing the same things, you start doing what somebody else has done. Maybe you're not aware of that. And once you start doing that and you're aware of that, And once you start working on the latest one, you start moving towards creating global standards for yourself. And then the next step would be to aim for global dominance. Now, why do I talk about this to a student audience? This has to start right from the time we start studying. This is not for big companies. This is not for when you get into R&D. This is not for when you start becoming big and you have entered into big positions to do that. No. Once you start learning, so once you are in college, even if you're in the first year or if you're in the final year, make sure that you start creating this awareness. You need to be aware of what is there, and you need to pass on this awareness. So I've given you an idea, a rough idea about IPR, the history and what it is and its relevance to India. And a very important thing is, what are the career prospects for me when it comes to IP in India? There are different ways that you could develop your career prospects. So you could probably work as a patent searcher. When I talk about a patent searcher, this is where you perform searches in different patent databases. This is something that I was doing when I was in-house as well, where you have R&D people coming to you with your inventions, and you try to assess their inventions before they go into the IP offices. And this is a very huge market in India, and there's a lot of area to grow in this area. There is a lot of scope as a patent searcher. You do need training for that, but that is one big career prospect. And you could also become a patent analyst. Now, what is a patent analyst and a patent searcher? A patent searcher, he looks for patent documents. A patent analyst is one who makes all those graphs, like I showed you in this slide. So these graphs, where they work with millions of patent data, and they study all of the patent data, and they derive these graphs. And this data can help inform a lot of people. So a patent analyst is someone who, now let me give you an example of what a patent analyst could do. Now, you're looking over here, and you're looking at this graph over here, and you're looking at China being number one, and Japan being number two. And in Germany, for computer technology, there's not much activity over here. That is what this graph says. So what does that mean? It gives you an idea to look over there and say, okay, what if I practice my invention in Germany? That's a good market for me because they are not big over there, and that gives me more space. China is more crowded. I don't want to get there. Germany I can use. So let me enter into Germany. You know, these kind of insights that you can derive from these graphs are very useful. Again, let me look at medical technology. When you look at medical technology over here, the number one is not seen over here yet. But then number two is the US, and there are spaces over here in these countries. Now, this does not mean that these countries are not active, but then these countries have possibilities where you can explore your invention. So these are some things that a patent analyst can do, and a patent analyst does, using a lot of tools and a lot of statistical analysis that's done to derive these insights. Another prospect is becoming a patent agent. And what does a patent agent do? I showed you how a patent looks like. And a patent agent, he helps to draft and also file patent applications with the patent office. Now, to become a patent agent, you need to write the patent agent exam of India. You need to pass the patent agent exam. And then the patent office gives you the license and calls you a patent agent. So this is some sort of accreditation, which means when I have to have help in writing my patent application, I would look for a patent agent. So I would ask for their licenses, and if they're licensed to be a patent agent, I know that they have some level of training to be able to understand and to be able to write a patent application the way it should be written. And you could also become a patent agent if you study the patent laws, and if you learn how to do that, and if you write the patent agent exam, you can always write that, and once you pass that, you can become a patent agent. Another last one is patent examiner. So what does a patent examiner do? This is the person who works in the patent office. So he is the one who checks your patent, who checks your invention, and then he decides to grant or revoke your patent. So there are these four avenues where you could go and explore, and these are the career prospects in IPR. So I hope I've given you some idea about how IP, the intellectual property rights work in India and how it's done. And if you need more help, please feel to ask me questions or please feel free to contact me. Thank you.
Thank you, Joshua,
Thank
for
you,
the
Joshua,
wonderful
for the
lecture.
wonderful lecture.
So we have
So
some
we have
queries
some
from
queries from
participants, and
participants,
before
and
that,
before
I
that,
would
I
like to
would like to
welcome all
welcome
the
all the
dignitaries
dignitaries
from
on
Joshua's side.
Joshua's side.
So
So
welcome,
welcome,
Renu.
Renu.
Shall I ask the
Shall I ask the
question?
question?
Yep, sure.
So the
So the
question is,
question
most
is,
of
most
us
of us
publish our
publish our
research in
research
most
in the most
reputed
reputed
journal,
journal,
including our
including our
PhD,
PhD,
and it is a
and it is
mandatory one.
mandatory.
Later,
Later,
patenting is
patenting is
rejected as
rejected
proof
as
of
proof of
concept is
concept is
already
already
discussed in paper.
discussed.
How to deal this?
Look, that is one of the things that I would like to caution you. Um, uh, if you have done your PhD, before you make that publication, make sure you file a patent application. And if you've already published it, if you have 6 months, if it's before 6 months, you could still file a patent application. But if you've passed that 6 month period, I'm sorry to say you will not be able to do that because it is already published, it is in public domain, and you will no more be able to file a patent application. So that is why there is a lot of research material in research journals published by our Indian researchers that should have gone in as patents, and they were not aware of that, and that has gone as research publications, and companies are free to use them. There is no restriction for these companies to not use them anymore. So I would strongly encourage you, if you feel that you've done a significant amount of work and it's worth protecting it, file a patent application for that.
So the next question is, transgenic crops are not easily accepted in India. Do you feel genome edited, that is CRISPR crops, will be accepted in India? If yes, when can we expect them in Indian market?
CRISPR is a very hot topic. CRISPR, there are 2 to 3 companies in the world that are fighting against it. And now, when you look at CRISPR, they are planning to make it available to the public as a democratic process. So anybody could use it because it's key. There are a variety of applications through CRISPR. And I recently attended a conference where the kind of applications that they were talking about CRISPR would increase longevity, and it would mean that there would be no death, so to speak, if CRISPR comes to the mainstream. They are planning to do that, and that will change significantly. Now, transgenic crops are a different thing. That is talking about genetically modified. CRISPR is a separate topic. CRISPR, we'll need to wait on that, on what's being decided. Transgenic crops, there are different ways of protecting the genes. You could file a patent application on the gene, and you could also register the gene with the gene bodies that are there with the European molecular biological database, if I'm not sure. I can check that information for you. So once you register your gene over there and at the same time file a patent application, you've got your gene protected. And you've got control over that. That is one basic way of protecting transgenic crops.
So the next question is, why is it not possible to apply for PBR for conventionally bred plants?
That is when you talk about plant breeder rights, you need to show different characteristics in that particular plant, and it varies between different countries as well. Plant breeder rights is not as uniform as how it is with patents. There are differences. Different countries offer plant breeder rights, and different countries do not recognize plant breeder rights. It depends on the laws of that particular country. For an Indian context, if we can show that there is a significant difference in what we have done in that particular plant variety, we can always file for a plant breeder right.
So the next is, what is the difference between patent license and technology transfer?
Good. That's a very good question. Technology transfer and patent licensing. This is a very big topic in itself. It is actually a big course, I would say, but I can explain it in short. Um, Universities usually do tech transfer. So what they do is universities, they file patent applications that come out of their research, and they try to create small companies, and then they spin out these companies. They do a tech transfer over there. Sometimes when we talk about tech transfer, they give exclusive rights to this particular spin out, and university somehow has some control over that, or they let that spin out be. But when you talk about patent licensing, this is part of the tech transfer when it comes to universities. But this is also a bigger picture when it comes to companies. There are companies who have patents and different patents. So if company A, so let's say, for example, in the company that I worked for, Covestro, we were dealing with polyurethanes. If our company was strong in one particular polyurethane, for example, and if we were not able to make another polyurethane, and if our competitor had that particular product, what we would do is we would talk to that company and say, would you be willing to license your patent to us? Which means that we pay some money and buy their patent for a particular period or for their whole lifetime. And in return, we grant you some access to our patents, which might be useful for them. So this is patent licensing. Again, there are many different kinds of licenses. And so patent licensing involves different companies who don't want to go through litigation, but want to come into agreement. And they say, okay, I license it to you for this period. You pay me this money. And if you pay me this money, you're free to go. And we saw the compulsory licensing, which the government of India did in the case of Bio, where they said, look, I'm going to take your patent for myself, and I will decide what I give you. That is compulsory license. The government compensates for that, but it will not be on the terms of the one who has the patent. It will be on the terms of the government, who does a fair assessment and gives the licensing as well. So this is patent licensing and tech transfer, in short.
So next query is, how much time does it take to get patent application get published?
Okay. When we are talking about your patent application, there's 12 to 18 months of time when the patent office would publish your patent. So once you file your patent, you have a 12-month period. I mean, this period is on purpose because you have different ways of filing your patent application. One, you can say, look, I'm going to file a patent application and I don't want it to be published because I'm going to make some changes and I want to have a think about the things I want to do, and then I'll let you publish it. So this is called a provisional application, which gives you 12 months to hide your application from being published. And you work on things, you add more examples, add more structure, and then you file a non-provisional application, which again gives you another 12 months of hiding, and then it comes out as published. So basically, you've hidden your application for 24 months from competitors, and if you've got something really big, you do not want somebody to get immediate access to the technology. So you've got 2 years of hiding period, and then when it comes out, it's already too late for them.
Okay, the next is, can we have a same patent application for multiple countries?
Yes, you can, and that is one of the things I said. If you have a patent application, and if you want to protect it in your country, in India, you file it in India. If you want to file it by your country, I mean, there are different ways of looking at it. If you have different researchers, I mean, if you have collaborations with different countries, they would want to file it in their country as well. So they can file it as well, the same application. But what you need to be aware of is, when you file it, you need to file it at the same time. You can't file it 1 year later, because there are definite limitations on that. Because once you file it after a certain time period, your application becomes a prior art for that one that you published, and you cannot practice your invention in that different country if you do it late. So you have to make sure that you do it all at one go. There are other ways of doing it, and I don't want to confuse you all over there. But yes, the short answer is yes, you can, but you need to do it at the same time.
Okay. And the next is, what will be the approximate cost for filing patent in India individually?
Look, the costs vary. The filing fees within the Indian Patent Office are not too much. It would be 10 or 20,000 or something like that. I'm not very sure about the cost for the filing, but the costs for writing a patent application, the cost for searching, that is huge. A patent agent, if he has to draft a patent application, would charge you anything over a lakh, if it is somebody who's really good at it. But again, having said that, there are also organizations that want to support Indian inventors, and there are also grants and funds for that. If you can apply for that, it is well and good. Or but if you look at it, normally it is a few lakhs for filing a patent protection in India.
So next query is, what if I don't commercialize after getting the patent? Will the exclusive right remains with me?
Commercializing decision is yours. You can do it or you don't have to do it. But if you don't commercialize, and if somebody else wants to enter into the market, and if your patent is blocking him, the first thing he'll try to do is talk to you, ask you to sell him your invention or license your invention. And if you don't want to do that, or if you're charging too much, he can take you to the court and say, okay, he has not commercialized his invention, I want to invalidate the patent. So the patent can be invalidated that way as well. If there is no hard and fast rule for you to commercialize as soon as you file your patent application, and even if it's granted, there are thousands or millions of patents that have not been commercialized. But if somebody wants to commercialize your patent, then the problem starts.
So the next query is, can polyherbal formulations can be patented for individual plants, because individual plants are known for some medicinal uses which has been already published?
Mm-hmm. You can. I mean, when you talk about individual plants and the plant extracts that are there, you might want to think about the particular extract from that particular plant that is active. Because you cannot patent a plant and say, for example, turmeric. You can't say turmeric is anti-inflammatory, and so we want to claim the protection of the use of turmeric. You can't do that. You can talk about curcumin. I mean, it is already known in the market, so you cannot patent it. Curcumin is the extract that has the anti-inflammatory property. So you need to talk about particular compounds that are active against particular diseases or disease conditions. And then you can file a patent on it if it's new and inventive.
Okay, so next query is, if I make a formulation from 3 to 4 herbs and make a formulation, okay, if I make a, once again I repeat, if I make a formulation from 3 to 4 herbs, can I file a patent?
Yes, you can. When we talk about formulations, that's a big minefield again. So if you say, let's say you have component A, B, C, and D. If component A is known, if component B is known, component C is known, component D is known, then you file a formulation patent or a composition patent and say B, C, and D is active against this particular disease condition, and you file a patent. But if A, B, C, and D is not known, then you would want to file individual applications for A, for B, for C, for D, or the combinations of it for A, B, A, C, B, C, or A, B, C, and think about the different permutations and combinations for that, and you file patents for that. This is done to make sure that you've covered the area properly and you have protection over that. Because if you filed only A, B, C, D, somebody can come and say, okay, I know A and B can do it, and it's way different from what you thought about, and then you've lost it, lost the plot. So it's useful to think about all of these combinations.
So that's all with the queries. Now I request Dr. B.K. Manjunath, Professor and Head, Department of Biotechnology, to speak few words about the web.
Thank you, Joshua, for your brainstorming session. Thank you, Joshua, for your brainstorming session. I hope all our participants got benefited from your beautiful lecture. One thing I want to add to all the participants, the patent filing in India will not cost you much.
Because if you go to the patent attorney, anywhere around 60,000 rupees you will charge for filing the, drafting your application. In case if you start reading as a student, if you start reading patent by now, by the end of your semester, when you complete your projects or ideas, so you will be able to draft your own clients, right? And prior art search, there are government agencies which will help you in doing that. NRDC is there, National Research Development Council, and even KCST is there in Karnataka State Council for Science and Technology. They will do the prior art search at free of cost for people. And for filing purpose, they will finance you for filing